So we're live back here with you, the World Crypto Economic Forum by Celsius, and really have a great group of panelists here, diverse group. We have Lisa Rubin, who's an associate at Paul Hastings, and Michele, who's a professor of law at Golden Gate University, and also is the funding director for the Blockchain Law for Social Good Center, or the founding director, I'm sorry. And then we have Francesca, who is the senior counsel at Protocol Labs, known for Filecoin. And so really happy to have all of you here. We have a diverse set of topics to discuss, and we'll have Lisa talk about NFTs for the first, for up to about 5 minutes, and then Michele will talk about regulation in California, and Francesca will talk about DAOs and DAO liability. So let's get started, and I'll kind of give the floor to Lisa, and feel free to talk about NFTs and current regulation around that.
Yes, thank you so much for having me. I'm very excited to be here. So as Jun said, my name is Lisa Rubin, and I am a blockchain and fintech attorney at Paul Hastings. We help both large companies and smaller emerging companies and investors navigate the regulatory complexity around crypto and blockchain. I have to say this is not legal or financial advice. So NFTs are a very hot topic, but regulators and lawmakers are also paying more attention. So in my opinion, the top 3 legal issues around NFTs are: 1, is an NFT a security? 2, who owns the copyright to an NFT? And 3, do you need to be aware of anti-money laundering laws? So for the first question, is an NFT a security? Generally, we look at a lot of different factors, but we use the Howey test. The Howey test has 4 different elements, which are: 1, is there an investment of money? 2, in a common enterprise? 3, with an expectation of profits? And 4, from the efforts of others. So you have to say yes to all 4 for there to be a security. Generally, if an NFT is a collectible item and doesn't have some additional high-risk factors, then the NFT generally could not be a security. Things that would increase the risk that it's a security are things such as if there's passive income or fractionalization, or if it's marketed as an investment mechanism. So there are a ton of factors, and each NFT should be looked at specifically, but if it's a collectible item, then generally it will not be a security. The SEC has not issued guidance specifically on NFTs, but they have recently added 20 new enforcement agencies or agents to their enforcement agent, and stated that they're going to start looking at NFTs more closely. So just something to be aware of. The next question is: who owns a copyright to an NFT? Generally, under US copyright law, it's the creator of an artwork, and in this case, an NFT, who owns the rights to an artwork if it's sufficiently original. So there's an interesting question if it's a completely machine-created NFT, whether it's sufficiently original to be an artwork protected by copyright law. But if it is sufficiently original, then the creator doesn't have to file anything or register anything. They just automatically have copyrights in that work. An exception to this is if there's an employee who creates an NFT in the scope of their employment, then it is likely the employer who owns the NFT and not the employee. There are a lot of really interesting cases right now that are just figuring this out. For example, Quentin Tarantino. You all know Quentin Tarantino. He's a famous director, and he created Pulp Fiction. He wanted to create Pulp Fiction NFTs, but the studio Miramax sued him, saying that they own the copyright to these NFTs. So that's currently early in litigation, and it will be interesting to see how that plays out. The third question is whether anti-money laundering laws apply to you. So FinCEN, a regulatory body, is concerned with financial crimes, and they recently issued a statement that they are watching NFTs more closely for bad actors that participate in illegal businesses trying to clean their money by buying artwork and now potentially NFTs. So if you are a platform selling NFTs, it would be best practice to develop a KYC policy or know your customer, which just means that you collect a lot of information on your customer so you can make sure they are who they say they are, and also develop policies so that if you see suspicious activity, you can flag it. So those are the top 3 legal issues, in my opinion, around NFTs. Whether an NFT is a security, if it's a collectible, generally not. 2, who owns the copyright to an NFT, generally the creator. And 3, do anti-money laundering laws apply to you? Potentially, and the best practice is to develop a KYC policy. So thank you so much.
All right, thanks so much, Lisa. And do we have any follow-on questions from Michele or Francesca about NFTs? Anything to add in this space?
I have a question, Lisa. Since you're in practice, are you seeing a lot of NFT, either artists or platforms coming for legal advice before they start operating or minting, or afterwards?
I would say most of the time it's afterwards. I don't know if it's necessarily consideration before, but we have gotten some projects before when they're creating, but I would say most of them are afterwards, and then they're interested in the protections and things like that.
Great.
I have a question too, which I get a lot, which is, what is the actual NFT? What copyright is associated with that record of ownership, and how does that record of ownership, the NFT, the hash, relate to the underlying work?
Yeah, so first, the creator would own it if it's sufficiently original. So there is kind of, I've had people ask me like, oh, what if I create this NFT of this famous basketball player or something, but that someone already owns that copyright, so it wouldn't be sufficiently original. And so if the artwork is sufficiently original and the creator owns it, when they sell the NFT, they don't actually sell the copyrights as well. I mean, unless they want to. So the buyer just has the right to display it personally to their friends and family, and then they can, but they don't have the commercial rights to like put it on a t-shirt and sell it.
Yeah. For what it's worth, I know the industry is working on ways to attach licenses in like metadata to NFTs so that you can sell some, all, or none of the IP rights easily without a ton of gas fees.
That sounds really great.
Yeah, fantastic. So yeah, really appreciate it. And we'll go on to the next topic, and please stick around, Lisa, and feel free to ask questions afterwards to Michele on regulation in California. I'll give the floor to Michele. Feel free to get started.
Great. Thank you so much for having me here. My name is Michele Neitz, and I am a professor of law at Golden Gate University School of Law in San Francisco. I've been a law professor for 16 years. I've been in the blockchain space since late 2017, and was delighted to be appointed to the California Blockchain Working Group in 2019, which was a 20-member advisory group to the California legislature, trying to figure out ways that the state could leverage this new technology to benefit Californians. It was a great experience, and it gave me real insights into the sorts of things that legislators and policymakers have to think about when they're considering whether or not to adopt any new technology, particularly in this case with blockchain. And a lot of what we talked about was, actually most of what we talked about was not crypto related. We really looked at non-financial applications of this technology. And I'll give you some examples. So we talked about whether or not voting via blockchain would be useful for Californians. And the working group decided, after hearing from experts in this space, that it's not mature enough yet and not secure enough to deploy blockchain voting at scale across California. But one that we found that we thought would work really well was with the state archives. And this is a very non-sexy use case, right? Putting state archives on a blockchain is not something that most people will jump out of bed for in the morning. However, it's actually a really cool use case for a distributed ledger. And it could create a lot of efficiencies for a large state like ours that has historical records, especially because we're so prone to natural disasters, that we really want to make sure are secure, are transparent, and are immutable. And so after the working group, we concluded our work in 2020, and we submitted a report to the state legislature. And then I noticed after listening to the congressional debates last summer that the focus was all on crypto, and that the folks who were debating in Congress were not talking about any of the non-financial use cases for this technology. And so I got really concerned that we're going to throw the baby out with the bathwater here, and we're going to try so hard to regulate from the perspective of public protection that we're actually going to stifle innovation on use cases that could be very beneficial to vulnerable members of society. And so that's what led me to start the Blockchain Law for Social Good Center at the law school, which is the first of its kind in the country. And we're really focused on educating regulators, policymakers. We just finished up we're just starting a partnership with the DMV, looking at ways in which the state could leverage blockchain. And so offering these neutral academic trainings to regulators in California and to policymakers has been very eye-opening. I will tell you that they're really hungry for education in this area, generally speaking, but there's a real, some folks who are very high up in understanding what blockchain is, and others who really just need a basic introduction to the technology. And so a lot of the work that the working group did culminated in the executive order that was just issued by Governor Gavin Newsom here in California. And he is directing departments within the state to solicit feedback from a wide variety of stakeholders to figure out ways that California can strike that balance between protecting the public and promoting innovation. And so I don't know if folks have noticed, but just today, actually, California's Department of Financial Tech Innovation has offered out a call for comments on the executive order. And so they're soliciting feedback, and this is your chance as folks in this industry to tell California policymakers, here's what we think we should see. And I can tell you that they do listen. I really commend the policymakers in California. We're not Wyoming. We're not nimble, right? We're a huge state. We have tons of diverse stakeholders in this state. And so moving us in the wrong direction would take a long time to shift back. And so that's why they're going to be moving very deliberately in figuring out how best to strike that balance here in California. So with that, I just want to do a plug. Please let the state know what you're interested in and what you would like to see, and any pitfalls that you might want the state to look out for. I think it's really important. This is a really important moment here in California to get your input heard. With that, I'll take any questions.
Great. Lisa, go ahead.
I think that's so exciting that you are teaching about this. So you had mentioned that you have kind of spoken with regulators, and I was wondering, in California, do you think that overall they're positive and accepting of it, or kind of more fearful?
That's a great question. So the center just launched in February, and I've already trained the executive staff of the state comptroller's office. I did train the Department of Financial Tech Innovation, and we now have this partnership with the DMV and other partnerships coming up. So I think that part of the problem, and when I'm talking to legislative aides, and I've talked to legislative aides in DC, who one of whom told me, you are the first constituent we've ever heard from who's not telling us don't regulate. And that's not a solution, right? They're never going to not regulate. So I think folks who are meeting with regulators and policymakers, it's really important that you understand how much they take the public protection part seriously, and how critical that is to anything, because they're the ones who will be blamed, as one of them told me. We'll be blamed if it all goes south, right? And so we're the ones who really need to watch out for public protection. So I think walking in with a public protection angle is a really important thing to do. That being said, they're eager to learn about this. They are seeing it in the news. Unfortunately, all they're seeing is crypto scams, because that's the narrative, right? And that's one of the things that the Blockchain Law for Social Good Center is trying to do. We're trying to shift that narrative toward socially beneficial use cases for this technology. And we welcome anyone who wants to be part of the center. You know, we've just launched, and we were launched with a grant from the Algorand Foundation. We have a very exciting partnership to announce shortly. And so we're really excited about the demand for these sorts of trainings and the interest that people have in learning more about this technology.
I have a question.
Sure.
How can non-California residents weigh in on California policy, or can they?
That's a great question. I'm not sure that there is any limitation on it. I didn't see any on it. I think if you were weighing in with an example of something that worked well in your particular jurisdiction, that would be very useful to the California policymakers, right? Like, I'm in the industry, I'm in this particular state, folks in Wyoming, you're gonna have a lot to talk about, right? And this is what's working well in our state. That would be useful information for California to have.
Awesome.
Fantastic. And yeah, and in terms of the executive order, what was kind of the highlight of the executive order for those that who haven't read it yet? So.
Well, that's a great question. So as I told my class here, I was teaching my blockchain law course. I'm still the only one in San Francisco teaching blockchain law right now, which is kind of surprising, actually. Berkeley, Stanford, they're all over, but in the city, I'm still the only one. So I told my class, we went through the executive order, which you can do. It's available online. There's also a summary press release. You will notice when you go through that the first few words are prevent, mitigate, like cautionary words that are used, right? And then the next round of words that's used is promote, and sort of focusing on the innovation part. And I think that's a signal. I happen to know from insiders that it was written very deliberately and very carefully, this executive order. And so I think that my opinion of this, knowing that, is that they're signaling we're going to take the protecting the public part very seriously, mitigating harm very seriously before we get into promoting innovation.
Great, thanks. That's great. And yeah, so for all of you, just as a reminder, feel free to put your contact information in the chat window for those that might want to contact you afterwards, either a Twitter handle or your email. But let's go to the last speaker, Francesca, and she's going to talk about DAOs and DAO liability. So.
Yeah, hi, I'm Francesca Cohen. I'm senior counsel at PL. I'll also mention that this isn't legal advice. I don't even advise any DAOs, but we do work with DAOs, so I know a thing or two. So I guess let's start by like, what is a DAO? And then also there's a recent lawsuit that was filed in California that we can talk about as a lens to understand some of the liabilities that relate to a DAO. So most listeners probably know, but a DAO is a decentralized autonomous organization. It's a group of people that's governed by publicly available code, most actions executed on smart contracts instead of some kind of central authority like a board or a bunch of humans. You could argue that many corporations are also decentralized, autonomous, and organizations, but a DAO is different because it's governed by code. And it is not associated with any particular legal entity by default, unless you make a choice to do so when you are creating the DAO. So what is this lawsuit that I mentioned? The key question in this lawsuit is whether a DAO without any associated entity is a general partnership. This is a really important question, and it's the first time it's really being legally tested. The reason it's important is because partners in a general partnership have joint and several liability personally for the full liabilities of that partnership. So if you are a partner in a general partnership, for all of its liabilities, they can come for your house, your stuff, whatever it is. You are missing the limited liability you get in LLC, aptly named, or a corporation. So this class action was just filed in May 2nd, on May 2nd in the Southern District of California. The plaintiffs are alleging that BZX DAO and its co-founders and some of its major investing members are jointly and severally liable for negligence because basically they said that they had security covered, but then they didn't. They fell for something like a phishing scam or something like that. And funds that they had invested in a DeFi protocol, $55 million, were stolen. So these plaintiffs are alleging that each of these named defendants should be personally liable jointly and severally for that full $55 million damages and anything that'd be awarded beyond that. By the way, I think it's noted on the schedule that Skadden is representing someone in this case. They are actually not. They wrote a great blog about it. The plaintiffs are actually represented by Gerstein Harrow LLP in LA. I looked up the complaint. Obviously you don't want to have unlimited personal liability, most likely. The legal field has long speculated that a DAO without an associated legal entity is a general partnership. Why? Because common law and the Uniform Partnership Act defines a general partnership as a group of individuals working together to make a profit, which looks a lot like a DAO, but we weren't sure that this would be how a court would determine this. So obviously, anyone who's part of a DAO who doesn't have a legal entity associated will be closely watching this case. There are some other issues at play here. I think the most important one is that the plaintiffs were probably also members of the DAO. Most DAOs will distribute governance tokens and people will vote with their tokens, and that will guide some of the actions executed on the smart contracts. So these plaintiffs holding those tokens, being members, were probably also partners in a general partnership. And whether a general partner can sue another general partner for the activities of that general partnership will likely be a question here, which I think will be really interesting how that comes out, because it will affect not only those DAOs whose members might not be shielded from liability, but others who might want to engage with that DAO in such a way as to just be minor participants, but they might, by becoming a partner, accepting some tokens or even doing some kind of work with the DAO without a formal legal contract, they might become a partner in the DAO and even for their small involvement be liable for its entire liabilities. There are also some jurisdictional questions that might come up in the case. California generally doesn't recognize jurisdiction over all of the members of a general partnership just because one member resides in California. So the court might use that and we might not get all of our answers. So this is going to be interesting. We'll see how it goes. I will use this to say, okay, now you probably don't want to find yourself in the position of the founder of this DAO. If you don't want to have unlimited personal liability, what are your options? If you do nothing, you face member liability. You probably can't file tax returns because you don't have a legal person to do it. And you're going to face difficulties entering into legally binding contracts because you don't have a legal person. But I am a lawyer. I do make corporations for a living. I should mention that there are some reasons that you might not want a corporate form and you might be willing to take this risk. You might have members of your DAO that want their privacy protected. They might not want to obtain consent from the members to form a legal entity. They might want to avoid corporate formalities that are not really congruent with decentralization, like appointing an authorized person. So you might choose to take this risk. But if you don't, you can create a legal entity. We've spoken a bit about Wyoming. Wyoming sort of famously supplemented its LLC Act so that DAOs could become LLCs. It's a pretty good option. It does apply some corporate rigor to your DAO, so you have to figure out if you like that or not. Others have suggested that you could use unincorporated nonprofit associations in US states where that's available. If you can argue that your DAO is not incorporated for profit, this might be a lighter weight option. This doesn't mean that you would be tax exempt and not for profit in that brittle sense, but rather you might incidentally make profit, but that is not the purpose of the business. There are also some DAOs out there that consider offshore structures. Many use offshore foundation type structures. In conclusion, my advice is, I am a lawyer, so take it with a grain of salt, but just get your LLC and double down on policy efforts to get in your jurisdiction DAOs recognized by something like the Wyoming LLC law, because this will legitimize DAOs and enable them to participate more in regular way business. That's my spiel.
Great, thanks so much. Michelle or Lisa, do you have any questions for Francesca?
I do. Do you, Lisa?
I do too, but you can go first.
Oh, I just have a quick question for Francesca about jurisdiction. So this case was filed in the Southern District of California in federal court, which is my former court where I clerked.
I wanted to ask you, what's the judge going to do?
Yay, Southern District. But what it's going to do is put the California federal courts in a bind, right? Because everyone's going to go to Wyoming. I mean, your advice is spot on, right? Like go to a jurisdiction where you can create an LLC to avoid a lawsuit like this. So it's going to put California in a real bind. We either need to come up with a way to encourage or to recognize legal entities for DAOs, or we're going to send everybody out of the state. So I thought that was, I don't know if there was a purpose to the jurisdictional choice here, but it's interesting.
Yeah, the complaint focuses a lot on the contacts, like the business of the DAO happening in California. I don't know, honestly, where the other founder or defendants live and if they're venue shopping. Maybe California's just better than the others. I'm not sure.
True. Yeah, it's interesting. It'll come out, I'm sure.
I was wondering, so I know you mentioned that you also have associated with a few DAOs. I was wondering if you've known of any that decided to use Wyoming. I know in practice, I've seen a lot of still like Delaware offshore. So I was kind of interested if you had seen actually people using the Wyoming law.
I think Wyoming is a great talking point because it so clearly applies to DAOs. But a Delaware LLC is fine. It might require a little more gymnastics because the act is not, formally structured for DAO. So you'll have to delegate some authority from the DAO structure and its code governance to that Delaware LLC. But I mean, Delaware LLC works and you have centuries of case law to understand how things are going to come out. So yeah, I mean, if it were me, I'd do Delaware LLC and make it simple. But Wyoming has a nice law with a nice name, so get a lot of press.
And that's so exciting that Wyoming has created that. So I hope California gets something similar.
Tell the regulators, now's your chance.
Great. Just one real quick follow-up on, I guess, the jurisdiction issue. So if California courts deem this DAO to be a general partnership, is that just isolated to now California, or if it's, let's say, another state, is that a precedent that's going to go across to other states? And the question about a general partnership versus a corporation, like how does that now kind of affect the federal level with this particular case? I'm not sure where it's filed, and so yeah, that's my question. Like, because just principally, I think that the idea that general partnerships are DAOs, or DAOs are general partnerships, actually is a good. It makes sense to me actually, but my concern is, okay, so if that makes sense, does that mean is this going to set a precedent? Does that mean it's just in the state or just nationwide? I guess.
I'll let Michelle correct me if I'm wrong, but generally, a court's precedent binds lower courts, so this would be instructive for other jurisdictions, but not binding.
With outside of the district, yeah.
Okay. Yeah, they're fascinating things. Yeah, just a lot of things. I think even Miko in the beginning talked about how, like, the DAO reneged on a contract that someone had as part of the DAO. So there was some. There's just a lot of like.
There's no legal entity. You can't sign a contract. There's no one on the other side of that contract. You don't have a binding agreement. I've had DAOs try to negotiate contracts, and I'm like, we can't. There's nothing to sign until you're a person. Yeah. I do think it's interesting how if the court does view this as a consumer protection issue, where the founders are seen as some kind of scammer, and we want to punish the founder, how does it weigh in that the members were also partners in the general partnership? And does that cut against deeming the DAO to be some kind of general partnership, or they're going to maybe apply some kind of fraud liability to get around it? I don't know. It'll be interesting.
Yeah. No, that's okay. No, that's great. It's a lot of interesting things, complex issues that are coming about. Really appreciate everyone here, and feel free to, again, leave your contact information. I know there's been a lot of questions and answers on the chat here, but really appreciate it. We do have another panel on regulation and fundraising. We have a couple people coming up. So if any of you want to kind of stick around for that, I think we could probably fit one or two of you, and just to talk about fundraising, more startup focused fundraising and regulation. And there is some issues about the DAOs I'm also curious about, but so that's maybe Francesca, we can maybe kind of have you talk about that as well, because I have a question about fundraising and general partnerships as well. But anyway, so really appreciate it. We'll be back in a couple minutes to talk about fundraising and regulation around that. Startups are always hungry to know what the latest trends are and how to raise money here in the US. So yeah, we'll be back in a couple minutes to tackle that topic. So thanks so much, everybody.
Thank you.
Thank you. Bye.